The political world is reeling tonight from an unprecedented legal maneuver that blurs the lines between comedy, censorship, and raw power. Donald Trump has initiated a stunning move to silence comedian Trevor Noah following a joke about the former president's alleged connections to Jeffrey Epstein. This isn't a public feud, it's a legal threat with chilling implications for free speech. A cease and desist letter, a precursor to a lawsuit, has been delivered. The contents of that letter, now obtained by our investigative team, reveal a strategy far more aggressive than anyone anticipated. This story begins with a punchline but is evolving into a constitutional crisis. The joke itself was delivered on Noah's new viral podcast weeks after his departure from The Daily Show. Noah, known for his global perspective, was dissecting the unsealed Epstein court documents. He highlighted the litany of powerful names listed from princes to politicians. Then he turned to Trump, noting the former president's well-documented past friendship with Epstein, including quotes from decades-old interviews where Trump praised Epstein's taste. The punchline was sharp, suggesting the only reason Trump's name wasn't more prominent in the files was because his infamous grab them quote was already public knowledge. The audience laughed. Trump's legal team did not. Within 72 hours, attorneys representing Trump dispatched a formal legal notice to Noah, his production company, and the podcast distributor. The letter, bearing the letterhead of a firm known for its scorched earth litigation tactics, does not merely demand a retraction, it alleges defamation, intentional infliction of emotional distress, and, most strikingly, tortious interference with prospective economic advantage. This last charge is the key. It claims Noah's joke directly harms Trump's ability to secure foreign business deals and licensing agreements for his properties. The argument is that the Epstein illusion brands Trump a pariah scaring off international partners. This legal theory is novel, untested, and legal experts we've consulted call it a profound stretch. But its purpose may not be to win in court. The purpose is to intimidate. The threat of a lawsuit, especially from a figure with the resources and temperament of Donald Trump, is a powerful silencer. The potential legal costs alone, running into millions of dollars, can force critics into submission. This is known as a slap lawsuit, a strategic lawsuit against public participation. Its goal is to censor, not to seek justice. Most states have anti-SLAPP laws, but a federal case could drag on for years. The historical context here is critical. Trump's relationship with Jeffrey Epstein was a subject of tabloid fodder in the 1990s and 2000. They were photographed together at parties. Trump once told New York Magazine in 2002, "I've known Jeff for 15 years. Terrific guy. He's a lot of fun to be with. It is even said that he likes beautiful women as much as I do, and many of them are on the younger side." That quote has resurfaced endlessly. After Epstein's first arrest in 2008, Trump distanced himself. In 2019, he claimed he'd had a falling out with Epstein years prior. The unsealed documents from the 2015 civil case brought by victim Virginia Giuffre contain testimony from a former Epstein employee. That testimony mentions Trump being at Epstein's Mar-a-Lago club but does not allege any wrongdoing by Trump. Trump has never been charged with any crime related to Epstein and has denied any knowledge of or participation in Epstein's criminal activities. Trevor Noah's joke exploited the public's murky association of the two men, a connection fueled by decades of photographs and that single infamous quote. The legal response, however, treats the joke as a concrete allegation of criminality. Our investigation into the law firm behind the letter reveals a pattern. This firm has been increasingly active since Trump left office, sending similar cease and desist notices to small town newspapers, former administration officials writing memoirs, and even a political action committee that ran an attack ad. The tactic is consistent: overwhelm the target with the prospect of endless legal warfare. In several cases, the mere receipt of the letter prompted immediate retractions and apologies from outlets lacking the financial backbone to fight. Trevor Noah, with his substantial platform and resources, represents a much larger and more public test case. Beyond the legal arena, the geopolitical ramifications are being quietly assessed in diplomatic circles. Trump, as the presumptive Republican nominee, is engaging with foreign leaders and billionaires. The latter's claim that Noah's joke impedes international business relations is particularly revealing. Which relations with whom? Our sources in international finance suggest a growing anxiety among certain overseas developers and state backed funds. They crave the brand power of a Trump Tower or resort but fear the reputational contamination of any Epstein adjacent scandal, no matter how tenuous. This lawsuit threat can be seen as a public performance to reassure those skittish partners the intelligence community is watching from a unique angle. For decades, Epstein's web was a counterintelligence nightmare, a honey trap of potential blackmail and influence peddling involving global elites. Any legal action that seeks to litigate the public discussion of that web is of operational interest. It signals who is most sensitive about their connections and how far they are willing to go to reshape the narrative. The aggressive move against a comedian, a satirist, is seen as an escalation in the ongoing information war that has surrounded the Epstein case since its inception. Let's dissect the emotional distress claim. The latter alleges Noah's joke caused Trump severe mental anguish and emotional suffering. This is a subjective standard, but it introduces a personal, visceral element to the legal battle. It frames Trump not just as a public figure toughened by decades of brutal media scrutiny, but as a victim. This narrative is politically potent. It feeds directly into the core message of his campaign that he is perpetually under attack by a corrupt elite. The lawsuit threat becomes a campaign rally talking point, a symbol of his resistance. The timeline is accelerating. Noah's team had a 10-day window to respond to the cease and desist. Our sources indicate they did not comply with the demand to issue a sweeping on-air apology and permanently remove the episode. Instead, Noah's attorneys, a top-tier First Amendment firm, sent a blistering reply. They called the Trump team's claims legally frivolous and constitutionally bankrupt. They cited the landmark case Hustler magazine v. Falwell, where the Supreme Court ruled that parodies and satirical statements about public figures are protected speech, even if they are outrageous. The stage is now set for Trump to file suit, and he has. As of this morning, a complaint was filed in a Florida federal court. The choice of venue is strategic. Florida's defamation laws are marginally more favorable to plaintiffs, and the judicial district includes judges appointed by Trump. The lawsuit seeks $400 million in damages, an astronomically punitive figure clearly designed for headlines. It also demands a court injunction ordering Noah and his distributors to never speak of Trump in connection with Epstein again. Such a prior restraint on speech would almost certainly be struck down, but the act of demanding it sends a message of intended dominance. The discovery process in this lawsuit, if it proceeds, could be explosive. Trump's legal team would have the right to subpoena Noah's writers, producers, and research notes. They could depose Noah for hours, digging into his intent. But in a twist, Noah's team would gain reciprocal discovery rights. They could demand Trump's schedules, communications, and records pertaining to Epstein. They could depose Trump himself under oath. This mutual assured destruction may be why many such suits settle quietly, but with both personalities being famously combative, a quiet settlement seems unlikely. The court of public opinion is already in session. On conservative media, the lawsuit is hailed as a long overdue stand against comedic assassination. Commentators argue that comedy has moved from punching up to spreading malicious conspiracy theories. On the left and among free speech advocates, the reaction is one of alarm. The chilling effect is real. Late night writers' rooms are reportedly pausing jokes, consulting with network lawyers in a way they haven't since the aftermath of 9/11. This self-censorship has begun, which is precisely the lawsuit's intended effect beyond the courtroom. Historical parallels are scarce. Presidents have been mocked since George Washington. Satire is embedded in the American tradition. The closest analogy might be the backlash against satirist Lenny Bruce in the 1960s, who was arrested and prosecuted for obscenity. His crime was using language that challenged societal norms. Today, the alleged crime is challenging a political narrative. The legal weaponization of personal offense by a former head of state is without modern precedent. It represents a new frontier where the power of the state through its judicial system is leveraged by a private citizen to punish speech. The diplomatic fallout continues. Several European media regulators in confidential briefings have expressed concern over the potential extraterritorial reach of such a lawsuit. Noah's podcast is global. If a US court issued an injunction, would platforms in Germany or the UK be compelled to comply? This creates a jurisdictional morass. Furthermore, foreign leaders who engage with Trump are now forced to consider whether their own past, perhaps a photo at an Epstein connected event, could become litigation fodder. The threat of legal action casts a long strange shadow over international discourse. Operationally, the intelligence angle deepens. Epstein's little black book, a document of phone numbers, has been a subject of fascination for years. Intelligence analysts note that aggressive litigation often serves as a signal. It can indicate an effort to control a specific narrative thread before it unravels further. By targeting Noah, who made a generalized joke, Trump may be attempting to establish a legal firewall. The message to future journalists or comedians considering a deeper dive is clear: you will be met with overwhelming legal force. This is preemptive narrative shaping through intimidation. The emotional tension for viewers is not just about politics, it's about the space for truth. Comedy has always been a vehicle for speaking truth to power. When that vehicle is threatened with a multi-million-dollar wrecking ball, the public loses a vital check on authority. The fear is palpable among mid-tier commentators and local satirists. If Trevor Noah with his fortune and fame is not safe, who is? This case tests the resilience of the First Amendment in an era where legal warfare is a tool of political combat and personal grievance. Let's examine the tortious interference claim in detail. To win, Trump's lawyers would need to prove Noah specifically intended to disrupt a known specific business opportunity. They would need to produce contracts or deals that collapsed directly because of the joke. This is a nearly impossible bar to clear. It suggests the lawsuit is less about legal remedy and more about creating a mythology of Trump as a business titan constantly besieged by unfair attacks. The court documents, however, list no specific deals. The claim is vague, referring to ongoing negotiations in the Middle East and Asia. Our financial investigators have been scrutinizing Trump's business dealings in those regions. In the past year, there have been reports of talks regarding licensing deals in Oman and Saudi Arabia. There were also rumors of a potential tower project in a Southeast Asian capital, though these have never been confirmed. The lawsuit's vagueness may be a shield. By not naming specific entities, they avoid forcing those potential partners into the public spotlight, which would likely scare them away more effectively than any joke. The legal strategy is therefore performative, designed for domestic political consumption. The psychological warfare element cannot be ignored. For Trump, the lawsuit is a weapon of distraction. It dominates news cycles, pulling attention away from policy debates or legal woes in his other cases. It reframes him as the aggressor, the fighter. For Noah, it's a sudden immersion into a world of depositions and legal brinkmanship far removed from a comedy writer's room. The stress is immense. Sources close to Noah say he is determined to fight, seeing it as a principled stand, but the personal toll is just beginning. The process is the punishment. Historical context of presidential anger at comedians provides stark contrast. Richard Nixon famously kept an enemies list and used the IRS to audit those he disliked, including comedians. But he did not sue them personally. Barack Obama publicly joked about being roasted by comedians at the White House Correspondents' Dinner. The tradition has been that the powerful endure ridicule as a price of the office. This lawsuit shatters that tradition. It seeks to legally mandate respect or at least silence from critics. It's a profound shift in the relationship between power and satire. The narrative momentum of this story is leading to a major revelation. Our team has obtained internal communications from within the law firm representing Trump. These are not the confidential attorney client discussions but internal memos regarding strategy. One memo written by a junior associate expresses concern about the legal viability of the emotional distress claim, noting that public figures have a much higher bar to clear. A senior partner's handwritten note in the margin reads, "Viability irrelevant. Scope is what matters. We are setting the perimeter." This is a crucial insight. The goal is not a single victory but to establish a perimeter of fear. That perimeter is expanding. In the past week, two popular political podcasters with far smaller audiences than Noah's have received similar letters for making offhand references to the Epstein Trump friendship. They have both taken their episodes down. The chilling effect is in motion and it is working with surgical efficiency. The legal threat against the biggest target, Noah, was the warning shot. The compliance of the smaller targets is the real victory. This is a decentralized censorship campaign funded by political donations to Trump's PAC, which is paying the legal bills. The diplomatic intelligence community is now analyzing this as a soft power maneuver. Autocratic regimes often use defamation laws to silence critics. By adopting this tactic, a former US president is implicitly endorsing a tool of censorship used in countries like Russia and Saudi Arabia. This normalizes the tactic within the Western democratic context. Diplomatic cables, we are told, have circulated expressing unease about the legal export of such methods from the US political scene. It's a blow to America's standing as a beacon of free speech, however imperfect that beacon may be. Operationally, the discovery of that internal memo setting the perimeter changes the game. It reveals a conscious, coordinated strategy of intimidation. This is no longer just about Trump's personal pick. It is a structured effort to reshape the media landscape through fear. The law firm is acting as a legal arm of a political movement. Their client list, which we are currently investigating, shows a pattern of representing figures accused in various court of public opinion scandals not to defend them in criminal court but to attack their accusers in civil court. The emotional core of this story is now a battle for the soul of public discourse. Can a joke be a felony in the eyes of a billionaire? The tension is between the liberating, anarchic spirit of comedy and the rigid, punishing force of law. Viewers feel this tension instinctively. They know something fundamental is at stake when a comedian needs a legal defense fund. The lawsuit has transformed Trevor Noah from a humorist into a symbol, a defendant in a case that will define the boundaries of laughter itself in the 21st century. We must now look at the man in the middle of this, Trevor Noah. Born in apartheid South Africa, his comedy was forged in a society where speech was literally a matter of life and death. He has spoken often about the power of jokes to expose the absurdities of oppressive systems. Now he faces a system of a different kind, the American legal system wielded as a blunt instrument. Friends say he is drawing on the resilience of his upbringing. He is preparing not just for a legal fight but for a very public demonstration of the cost of speaking truth. The political context is heating up as the election nears. Every hearing, every legal filing in this case will be a campaign event. Trump will rally supporters around his fight against the corrupt comedian media. The base, which already views mainstream comedy as a political opponent, will be further energized. This lawsuit is a campaign strategy disguised as a legal grievance. It galvanizes donors, dominates media, and paints the opposition as malicious slanders. The political ROI on a $400 million lawsuit claim, even if it never goes to trial, is incalculable.